Hello there, my name is Stephanie Rojo, and I'm an estate planning and estate administration attorney from Stone Law Offices in Las Vegas, Nevada. What I would like to discuss with you today is estate planning blind spots. What do I mean by that? Estate planning blind spots are basically pitfalls that you are unaware of. And my hope today is that once I bring these blind spots to your attention, you are encouraged to pick up the phone and call your estate planning attorney, make adjustments as needed, or redo your documents or improve your plan. So let's talk about some of these common estate planning blind spots. The first estate planning blind spot is no estate planning documents in place at all. Basically, you are just moving on through life, hoping for the best, and also hoping that things are going to work out in the event that you become incapacitated or you pass away and you don't have any documents in place. So not having documents in place is inviting problems, to say the least. It means that there could potentially be issues in the event of your incapacity or your passing as to who is going to step up to the plate to manage those affairs, who is going to take the time to seek permission from a judge, who is going to be the beneficiary in the event that you've passed away. There's all sorts of things that need to be hammered out, and not having an estate plan is once again inviting trouble. So you're better off talking to an estate planning attorney to figure out what your options are based off of your needs, your assets, your family circumstances, things like that. Doing it yourself documents is another huge blind spot. You think maybe it's not a blind spot because the person knows what they think they're doing. Well, I would let you know that the person probably doesn't know what they don't know. When you're creating your own estate planning documents, you're probably doing some Googling, you're probably purchasing a trust in a box or will in a box or something of that nature, and you really don't have the education or the understanding to know if your plan is really going to work out when you need it to work out most. And estate planning attorneys, estate administration attorneys, they really see these problems play out in reality. Day in and day out, we have clients come to see us who are dealing with these situations themselves, or they've created their own trust structure themselves, their own last will and testament themselves. They pass away and their family members are trying to clean up the mess, basically. And they come to our office to help them resolve the poor planning that was done during their lifetime. So I would absolutely say that do-it-yourself planning can lead to even more problems depending on how bad those documents are. It's better to pick up the phone, make a consultation with an estate planning attorney to figure out what your options are. And chances are it's not going to be as expensive as maybe you might have imagined it would be. Another huge blind spot is not aligning your assets to your trust if you've created that. That's huge because your trust can only do so much. And if there are no assets titled into that trust, retitled from your individual name into the ownership of the trust so the trustee can manage those assets, there's not a whole lot that the trustee can do. So if you have a shell of a document but no assets in it, the trustee is going to need to coordinate with the executor of your last will and testament to get a probate initiated to push those assets into your trust. So we spend a lot of time educating our clients here at Stone Law Offices regarding their individualized assets and how to retitle their assets into their trust. We even offer some programming where we have a client care coordinator who can assist clients with the direct transfer of their assets, with the direct alignment of their assets from their individual name into their trust. If you have questions about the client care program through Stone Law Offices, you're welcome to reach out to us and we can let you know how we can help you out in that area. Another huge blind spot, I'm trying to hit a few different blind spots here. Another blind spot is not communicating with your beneficiaries. Or communicating with your trustees, your executor, or your other named fiduciaries in your document. So you might have a plan in place, but nobody knows about it. That's a big problem. Or you have a plan in place, a couple people know about it, but they don't understand why you did what you did within your estate plan. Now that is potentially an issue waiting to bubble up to the surface upon your passing. It's better to communicate with beneficiaries to say, hey, I have a plan. It's with this attorney's office. Contact them if something happens to me. Or you might want to take it even further to explain, I've decided to give you this percentage and your siblings this other percentage, or I've decided to make these distributions this way for these reasons. And you go into a little bit more detail, so that way when you pass away, those questions aren't still in the open with those beneficiaries, and they're less likely to open a suit to challenge your estate plan. Okay. And then another blind spot that I really would like for you to be aware of is you have an estate plan in place. Maybe you did the right thing and you did create that estate plan with an estate planning attorney. However, it's been years and years and years. You can't even remember the last time you saw your estate planning attorney. You don't even know what they look like anymore. Maybe they've gone out of business. Bottom line, you have outdated documents. The people who are named in your documents are no longer alive, or you had a falling out with them, or the assets that you once owned when you created that estate plan are no longer in existence, and you got all new assets and they were never put into your trust. So there's all sorts of things that could make your estate plan outdated, but having an outdated estate plan is a huge issue, because just like a trustee of a trust has very little very little that they can do with a trust that doesn't have anything titled in it. If you have a trustee trying to administer an outdated estate plan, they're going to run into challenge after challenge after challenge. The good news is that if one of these blind spots maybe is something that applies to you, or if you're thinking, well, it could apply to me, there are ways to address these blind spots, okay? And let me tell you, the best way to address these blind spots is to call an estate planning attorney, right? Picking up the phone, calling an estate planning attorney's office, scheduling a consultation to discuss where you are, where your estate plan stands, how your estate plan can be improved, maybe how your estate plan can be replaced. It just depends on the factors that are particular to you. That estate planning attorney is going to want to know what you have, who you want to leave it to, how you want to leave those things to those folks. Who do you trust to step into the role as trustee or into the role as your executor? It may be that you moved from a different state and you need to get some new state-specific documents, like a healthcare power of attorney and a financial power of attorney updated. There's all sorts of things that can be reviewed and analyzed with an estate planning attorney, because bottom line, if you're not meeting with an estate planning attorney, you're figuring it out on your own, or you're using the internet to help you, and that can lead you down a deep, dark rabbit hole. And I want to save you and your family the trouble and potential issues that can come up with having one of these blind spots and not properly addressing it when you have the opportunity. So I'd love to talk to you if you have an existing plan or you have no plan at all, but you're ready to have the conversation to get started. My name is Stephanie Rojo. I'm an attorney at Stone Law Offices in Las Vegas, Nevada, and my number is 702-998-0444.